Okay.
Okay, we are live. Wonderful. So, welcome to another installment of the Center for Elder Law and Justice Facebook Live presentations on different topics. My last presentation was on immigration with Fidel, who is a fantastic individual. But the other thing I do in my office, in our office at CELJ, is foreclosure prevention. The Center for Elder Law and Justice is a member of the Foreclosure Prevention Project, along with the Legal Aid Bureau of Buffalo and the Western New York Law Center. So together, our three agencies work to provide free legal representation to homeowners facing foreclosure, to ideally keep them in their homes if at all possible, but if not, to get a better outcome on the foreclosure than just the property being auctioned off. So today we are going to talk about the foreclosure process and how COVID has affected it. So we're just going to go through an outline of what that foreclosure process looks like normally, and I will chip into where COVID has impacted it. COVID has delayed things. I'm sure after the past 10 months now, everyone knows that things have changed. So we're just going to go over how things have changed and how you can expect this process to look like going forward. My name is Alex. I'm one of the staff attorneys here at Center for Elder Law and Justice and the foreclosure prevention attorney at our office. So I will be happy to answer any questions that come up during this presentation. So if you do have any questions, please drop them in the chat, or if you're watching this later on, feel free to email Center for Elder Law and Justice or give us a phone call, and we'll have some more information on how you can do that towards the end here. So the title of this presentation is COVID foreclosures in the time of COVID and beyond. And the reason I chose that title is because certainly COVID is affecting things now, but we can expect this for COVID pandemic to impact how foreclosure proceedings work, likely for the next couple of years. Mostly because once people are getting vaccinated, thankfully that is starting to happen, and get back to a more normal lifestyle or a normal day-to-day operation, we can still expect a lot of people to have fallen behind because on their mortgage payments because of their income going down. Maybe they got laid off during COVID. Maybe they unfortunately had some health complications because of COVID. So this is something just on the borrower end is going to probably last a couple of years in terms of how it's going to impact homeownership as well as foreclosure proceedings, but then also with the court system. The way that things have gone virtually over the past 10 months is really paving the way for a lot more virtual appearances, a lot of changes as to how the foreclosure process has traditionally worked versus how it's going to probably work now and going forward. And we'll get into all of that. But first, our general presentation disclaimer. So the following content, it is just for informational purposes only. This is not legal advice, and what I say today may or may not be applicable to a person's individual situation. So if you have any questions or you're facing a foreclosure, you should contact an attorney for advice about your specific situation, because your situation might be different than the general overview we'll discuss today. And again, at the end of the presentation, if you want to contact the Foreclosure Prevention Project or the Center for Elder Law and Justice, there will be information on how you can do that as well. So first of all, I want to go over how mortgage foreclosures in New York State work generally. And there is a difference between a mortgage foreclosure and a foreclosure based off of unpaid taxes, user or water fees, or any sort of payments to a town or county. And we'll get into how that is working right now a little bit later on. But we'll start with mortgage foreclosures in New York State. And each state does do things a little differently with regard to foreclosures. In New York State, contrary to what you might have heard, mortgage foreclosure is not a quick process at all. In some circumstances, it can take years for this to work through the court system. You're looking at a process that has been bolstered to give the borrower a good chance to retain their house if at all possible. And in order to do that, the bank or lender or mortgage company, I do use those words interchangeably. So sometimes it might be like a bank or a private mortgage company, but I use those words interchangeably as sort of a verbal shorthand. They do have to follow some specific steps in order to foreclose on a mortgage in New York State, and involves bringing a lawsuit, going through a settlement conference process, which we'll get into, bringing a motion to find out how much is actually owed on the loan in total, and then bring another motion with the courts to actually get the authority to sell the property at auction. And throughout that process, which again is quite lengthy, there are plenty of procedures and systems in place to help borrowers really work with the bank to keep their homes if at all possible, and give borrowers a chance to answer any complaint or provide any defenses to the foreclosure action. Biggest thing for an individual borrower, and that's what I'm going to call people who take out a mortgage or who have signed a mortgage, is just borrowers. You could potentially call them debtors, for example, but I feel like borrowers is the best word because it encompasses not just the person who might be paying day-to-day, but everyone on the mortgage document itself. Best thing you can do as a borrower, pay attention to the process and be involved in the process. If you're starting to get mail from your bank or your mortgage company, maybe you have fallen behind on payments, look at that and make sure that that is something that's applicable. Don't just throw it in the trash. That's probably one of the worst things that anyone can do, is to start ignoring their mail because there might be some useful information in there. And then, of course, now, because of COVID, New York and the United States federal government have implemented additional protections for borrowers in light of COVID-19 and how that's impacted people. However, one really big rule and caveat to that is that if the property is vacant, those additional protections will not apply almost 99% of the time, because what these additional steps basically look at is, okay, we want to keep people in their house, we want to keep home ownership up, but if the property is already vacant or if someone's moved out and not maintaining it, they want to make sure that that's not going to deteriorate further and put a pressure or a burden on the community. So getting into how does a foreclosure first start? And that's pretty self-explanatory, and it does start with what's called a hardship and a default. The hardship's going to come first, and that's the reason why a borrower fell behind on their payments. So especially now, unemployment or loss of rental income, for example, or increased medical expenses is something that we're seeing a lot more now. Anything like that, anything that made a borrower unable to make their normal monthly payments. Just up in deciding not to pay your mortgage is not a hardship, and you're going to lose the protections that the state court system puts in place if that was why you stopped making payments. And the bank's probably not going to work with you as much as they normally would. And then once we get a hardship, you've missed a couple payments, you'll get into what's called default. And default is a legal term. It is essentially when you've missed enough payments that you've broken your contractual obligation under the mortgage. So mortgage is basically, and I'm going to oversimplify this a little bit, but basically a mortgage is a contract between you and a lender. And you as the borrower, the lender agrees to pay you a sum of money to purchase a property. You agree to pay so much per month at a certain interest rate for however many years. Typically 30 is the standard, but it could be 15, could be 20, could be 40, depending on your situation. And you will agree to pay that monthly payment each month. Now, if you break that obligation, you are obligated to pay that much per month. If you break that obligation, the lender does have the right to initiate foreclosure proceedings to sell the property and recover any unpaid amount. In that sense, the property is collateral to the loan. It is not because foreclosures do have all these protections, it's not really analogous to, say like a car loan, for example, where the car is collateral and they can repossess it. But thinking along those lines is helpful as just a basic idea of what this looks like. A lot of times missing one payment, you're not going to be a default from doing that. You'll have an opportunity to just make that up and pay your past month's payment and then your current month's. There's probably going to be some fees and costs associated with the late payment. That's usually very standard and something you agree to in the mortgage. So typically you're not going to be in default until you've missed close to 3 or 4 payments in a row. And if you do that, the lender may not accept normal payments anymore. So for example, say that you're, for the sake of the math being easy, you agreed to pay $1,000 per month and then you missed 3 payments. Well, the lender might not accept your $1,000 anymore. They might say, okay, well, you've missed enough payments, you're in default, we need that $3,000 to bring you current, or else we're not going to keep payments. That is allowed. That is something that the lender is allowed to do to protect its interest. And they will add late fees, and interest will continue to accrue as long as the loan remains in default. And that could take a while. A loan in default can remain in default until it's foreclosed upon, and it will impact your credit score as well. So a lot of that, by the time that a foreclosure action has been started, you have probably already missed a few months, if not more, payments. So at that point, it might be a good idea to look at some financial counseling if that's needed, or if your hardship was unemployment, but now you are employed and the bank isn't willing to accept its normal payments, that might be something where you'd want to consult with a housing counselor and have some more information on that as well. So COVID protections regarding the hardship. These are newer protections that were put in place back in the late spring, early summertime. If you are experiencing a COVID-19 related hardship, you may be able to get a loan forbearance. That does not require you to have had COVID-19. It just requires that you had a hardship that was caused by COVID-19. So you might have, if you lost your job or were laid off because of COVID-19 related shutdowns, that's usually enough to qualify for a forbearance. Forbearance is just a fancy word saying that we're going to put your payments on pause, and you're not going to be required to pay on your mortgage for a specific period of time. It's typically 3 months or 90 days. And then gives you time to deal with the hardship, sort of resolve that. And then when the forbearance is up, you can start making payments again. How long your forbearance is going to last and what the conditions are when it comes to paying that amount back, it's going to depend on your individual mortgage servicer. And the servicer is the company that you talk to and deal with when you make your payments. So some companies might want to offer a 6-month forbearance off the bat. Some want only the 3 months. Some will say, okay, we're just going to extend your loan term for that 3 months that we gave you at the end. Others will say, well, okay, this is going to be a balloon payment. You'll need to pay all at once when your loan matures or when you finish making your normal payments. So it is going to depend on your company specifically. So that is something that you would want to call your company about to check on and see. If you have experienced a COVID-related hardship and you think you need a forbearance, always better to call your mortgage company sooner rather than later. Because if you call and catch it and get put on the forbearance before you would miss a payment, then that's not going to count against you in terms of getting to a position where your loan might be in default. So always good to do that. Or if you have not resolved your hardship by the time the forbearance is running out, say when you've got another month or so left, see if you can extend that. Call your company again or your mortgage company again and see if you can extend that. Always good to try that well in advance of when anything's going to run out. So after the default, in New York State, the banks or lenders are required to send what's called a 90-day notice. And they have to send that to the borrower, informing them that if the missed payments with the additional interest or late fees isn't paid within 90 days of receipt of that notice, they will start foreclosure proceedings. It's going to look like a letter saying that you have 90 days to pay this back, or else we start foreclosures. About the language, it sounds as though you've got 90 days before your house is going to be sold. That's not the case. That's 90 days before they start a foreclosure action in court. It doesn't mean that you've already been foreclosed on or the lender is going to sell the house. It gives you a notice that this is upcoming, so you can try to cure the default or pay what you owe back to the bank. This specific notice is required by New York State law, and it is required to be sent to all borrowers on the loan. Even if there's only one person who's actually making the payments, or a borrower has been moved out of the property for even a couple of years, they're still required to send that notice to anyone who's listed as a borrower on the mortgage. And they will, if at all possible, track down all the borrowers to make sure that they get this notice, because that is something that if they don't do properly could impact the ability to go through with the foreclosure. But for more information on that and whether that applies to your situation, I recommend contacting an attorney. After the 90 days have elapsed, if you haven't paid the loan back, the bank will file what's called a foreclosure complaint. And a complaint is just the word for the document that starts the lawsuit, which is the foreclosure lawsuit. You are being sued by the bank. And it's going to be filed with the appropriate county court or New York State Supreme Court. And New York State's a little weird. The New York State Supreme Court is actually the lowest state court. So it's not like they're taking this up to the highest end of the chain. Now, this is going to be something that's going to be close to you. Buffalo has a courthouse downtown where you have judges from your state Supreme Court and from county court as well. And the lender will serve or send the copy of the complaint and what's called a summons, just basically saying you have a lawsuit filed against you. You need to respond to this to the borrower. You can expect that to be maybe in the mail. You might get it served directly, so someone might show up and hand it to you. Typically, it is mailed. Once that happens, the borrower has 20 days to answer the complaint, or what we say is filing an answer. And that's just saying you are raising some defenses to the foreclosure, basically calling into question the bank's ability to foreclose. You do get 20 days after you get the complaint to do that, but you can get more time if you take advantage of the settlement conference process, and we'll talk about that in a few moments. The lender will almost certainly, at the time that the complaint is filed, start adding their attorney's fees onto what you owe them. That is something that almost every mortgage contract that you sign has in it, that if you are in default and they do need to start a foreclosure, they are allowed to add their attorney's fees onto what is owed. So you can expect that number or amount that you owe to jump up a bit at the time that they file the complaint. It could be even a few $1,000s, unfortunately. And once the complaint is filed, foreclosure actions or foreclosure lawsuits are public information. So if you something is filed against you, you may see on different realty sites like Zillow that the house is in pre-foreclosure. That means a foreclosure complaint was filed. You may see something. You may have people call you asking, "Hey, do you want to sell the property? We noted it was in foreclosure proceedings." That is because the foreclosure is public information. And the other thing that you want to know about the complaint is that a bank will name all of the borrowers as defendants to the foreclosure. And all borrowers can be liable for the mortgage, even if there was a divorce. So say that borrower A and borrower B, they both signed a mortgage together as husband and wife or as a married couple. And then they get a divorce. We'll say that they get a divorce 5 years after they sign the mortgage. In the divorce, borrower A agrees that they're going to pay the entire mortgage. Borrower B, in the divorce decree, it says, okay, you don't have to pay this. Great. Maybe borrower B even deeds their interest in the property over to borrower A. So A is the only one who even owns the house. Because borrower B signed the mortgage with A, B is still going to be named as a defendant and could potentially be liable for that debt if A is not able to make the payments. Just showing the divorce and decree and saying that you're not responsible, that does not relieve the obligation that you owe to the bank from signing the mortgage. So something to be aware of, something to consider if you're in that circumstance. It could impact your loss mitigation options, but you will also be named as a defendant. Next is an answer. Answer is just a document that you file with the court disputing the claims that the lenders made in the complaint. You basically are raising issues that call into question the lender's legal right to foreclose. I'm not going to spend a whole lot of time on this because there are still some standard defenses that you would raise. They're not applicable in all circumstances, so you should really consult with an attorney before filing an answer to make sure that you're tailoring it to your specific arguments, and you can make it, you can sort of avoid all of the arguments that don't apply to you or defenses that don't apply to you, and make it a lot easier for the court to deal with, and might make it a little stronger as well. So I would recommend consulting with an attorney on that if you have any questions about filing an answer. Okay, moving on after the answer to the settlement conference part. Now, this is something that New York State does. This is statewide. And it is a procedure. It's meant to give the borrowers a chance to negotiate a workout with their lender in what's called good faith. Basically, what the settlement conference process wants to let people do is to let the borrower and the lender sit down. There's going to be a court referee who's overseeing these negotiations to try to come to a solution that keeps the borrower in the home and lets them start making monthly payments again. The court will schedule a settlement conference for each foreclosure case. We'll get at least one, and they will send a letter to the borrower telling them when that first conference will be held. It's usually going to be sent to the property address. Keep an eye on your mail for that. It's really important that if you want to stay in the house that you go to that, because when you're in settlement conference part, and this could last for months, we'll go into a little bit more of how those work. But while you are participating in these settlement conferences, the foreclosure is on hold per state law. Bank can't move forward. Bank can't file any motions to try to claim your house while you're in settlement conference, unless they get special permission from the court, which usually doesn't happen. So it's important that you're involved in this process as a borrower. And the reason that you'll hear a lot of foreclosure attorneys harping on staying in conference is because getting that time where the action or foreclosure is not moving forward, that is so invaluable to a homeowner. Gives you time to look at your options, gives you time to get a plan in place, and ideally, it gives you an opportunity to resolve the foreclosure before it even goes to a motion or goes any farther or any closer to an auction. It's a really, really good opportunity for borrowers and something that should be taken advantage of. And we'll go into the specifics on that in the next slide. But beforehand, I want to let people know that the Foreclosure Prevention Project agencies traditionally have attorneys at these initial settlement conferences to conduct an intake and provide assistance with the first conference. We also try to get people connected with an attorney who can represent them in the long term with one of the Foreclosure Prevention Project agencies at no cost to them. So it's showing up traditionally will have gotten you at least the opportunity to get an attorney as well as stall or put the foreclosure on a little bit more hold. COVID update here is that the courts aren't currently scheduling first conferences. So that means that a lot of foreclosures aren't moving forward because they can't move forward until these conferences happen. I expect that the courts will likely start to schedule these conferences sometime in the beginning of 2021. I'm not sure yet when. They will be held virtually until further notice to comply with COVID restrictions. If you need to be there for whatever reason to appear, or you don't have a computer or you don't have access to a way to get onto a virtual conference, There will be a kiosk at the courthouse where you could do that. And if you are able to get to the courthouse that day, wear a mask. They will have the appropriate COVID precautions in place, but there'll be a kiosk where you can access the virtual conference. However, to make things run much more smoothly for you as a borrower, please call the Foreclosure Prevention Project. We got the number right down there. That is 716-828-8428. That is the Foreclosure Prevention Project intake line. Please do that before your first conference, ideally a couple of weeks beforehand, so we can do an intake and help make sure that you're connected with an attorney who can represent you at that first conference. Again, this was at no cost to you as a homeowner. So please contact, if you get that notice, it's usually going to be 30 days before your conference. Absolutely, we recommend contacting Foreclosure Prevention Project before your first conference so we can get that set up, and then you won't need to deal with the virtual stuff. A little bit more on the specifics of how the conferences work. They are run by a court referee, not a judge. So you're not going to be in front of a judge when you go to your first settlement conference. A lot of people will think that, hey, this is the only chance I have to argue why I should stay in my house. It's not the case. You're not going to walk out of the first settlement conference with your house being sold. It's also not the time for either side to argue why they should or should not be able to foreclose on this property. The court referee is a judge's law clerk, and I've gotten to know quite a few of them over the course of the past few years doing this, and they're all pretty fair in terms of making sure that everyone gets an opportunity to work with the bank or try to work out a solution that lets them stay in their house. And that's what the job of the court referee is to make sure that both the bank and the homeowner come together to negotiate what the magic buzzwords for the court are: a mutually agreeable resolution. What that looks like is typically a loan modification, which we'll discuss. And like I said before, while you're in settlement conference part, the foreclosure will be put on hold. So the court will schedule quite a few of these, so long as you're continuing to supply the bank with information in good faith, you're willing to work with them. If you drop off the face of the earth for 2 or 3 months, that's not going to help. That's where they'll say, okay, well, the borrower's not really showing up, so we're just going to let the bank go forward. The initial conference, a borrower will be asked 2 questions. Do they live in the property, and do you want to keep the property? You answer yes and yes, then you'll qualify for the settlement conference part, and the court will typically schedule another one 60 days from your first date. So that's your qualifications. You have to live in the property and want to keep it. If you qualify for settlement conference part, they will schedule a follow-up conference. The reason that it's 60 days out is that you will receive what's a loss mitigation application, and you'll be given 30 days to submit that to the bank. The bank will then be given 30 days to review that. They'll most likely request additional documents after that 30 days or even before that 30 days. So, and that's really just say you get we're around the holiday season, so you get a holiday bonus. And that shows up on your bank account or your bank records. The bank might see that, your lender might see that and say, okay, that's odd, you're getting this extra income coming in. Is that a regular thing? And they'll say, hey, can you explain what this extra deposit is? You just go and say, have a signed quick letter saying, oh, this was a holiday bonus. It was one time for the holidays. It's not something I get every month. So long as everyone's continuing to negotiate or in good faith, the case will stay in that settlement conference part and the foreclosure will stay on hold. Good faith typically means for this that you're complying with reasonable document requests, that you are submitting them in a timely fashion, that you are not just waiting until the last minute to get a loss mitigation application that the bank will not be able to take just to get that delay. But that's going to be specific to your situation. So I'm not going to get into too much more detail on what that looks like. If you do have an attorney, they will appear on your behalf. You don't need to be at that conference. You are not going to be looked down upon by not being present if your attorney's there, because the court, the bank's attorneys, and most people involved say, hey, if you've got to work, better for you to do that so that you can make payments and keep paying on the mortgage, rather than showing up at court once every month or once every other month. And then at that point, you are going to want to submit that loss mitigation application. So loss mitigation basically is working with the bank to avoid a foreclosure auction. And you submit an application with supporting financial documents. That's typically, if you're employed, 2 months worth of pay stubs, 2 months worth of bank statements. If you have Social Security, it might be an award letter, but that's going to be more specific to your situation. You are required, if you want to be considered for loss mitigation, to submit those financial documents. Failing to do so will mean that the bank will almost certainly not approve you for any sort of loan modification or any other relief option. Common outcomes from loss mitigation, loan modification, this is really the preferred outcome, because what this does is it restructures the loan to bring a borrower current and set up a new payment schedule. So sometimes people compare this to a refinance. It is not the same thing. It is different but similar. It is, from a legal perspective, it is distinct. It's not a refinance, but it is similar in that the bank will alter the terms of your loan to catch you up and ideally make the payments a little more manageable. Your payments might go up depending on how long the loan has been in default and how much you owe and what the current interest rates are, for a whole host of other reasons as well. Payments might also go down. So the big benefit, though, is that it resolves the foreclosure, keeps a person in their home, lets them start making payments again on their loan so that they can stay current and stay in their house. Next most common outcome from loss mitigation is a short sale. That is when you sell a property for less than what you owe on the mortgage. And when you do that, you do need the bank's approval, because they will be forgiving whatever the short sale does not cover that you owe on the mortgage. However, if you owe less than what the house is worth and you just want to sell your house for whatever reason, pay off the loan and relocate, so long as you're able to pay off the mortgage, you can do that as well, generally speaking. And might be a good option. Again, that's completely up to an individual borrower if they want to sell or relocate for whatever reason. But if they can't pay off the loan, they will need to from the proceeds of the sale, but then anything that's left over should go to them, absent any other debts, of course. The other common loss mitigation outcome is a deed in lieu of foreclosure. And what that is it's the borrower deeding the property to the bank and then moving out. So it is a relocation option, much like a short sale is. But the bank will usually forgive the remainder owed. They'll say it's much more cost effective for us to just have you deed the property than go through the rest of the foreclosure process. Sometimes with the deed in lieu or short sale, they might provide some cash assistance for relocation, typically a few $1,000s, but that depends on the individual bank, what they're willing to provide. Like I said before, the loan modification is the ideal outcome because it's the one that is most common that lets you stay in the house. The bank will, if you're approved for loan modification, they'll start you off in what's called a trial payment plan. Because we abbreviate everything in the world, that's what's called a TPP. And the TPP will last usually 3 to 6 months. There are some outliers where it lasts a little shorter or a little longer, but that's the most common. Banks just looking to see you can make a monthly payment on a regular basis again. This is basically a trial run to your new monthly payment structure. Once that's completed, the bank will roll you into a permanent modification, issuing documents that, once executed, will supplement your mortgage and changes the terms a little bit and keeps you in the house. At that point, it resolves the foreclosure, and now you're paying according to the modified loan. The lender will take the missed payment amount and whatever fees and costs they've accrued as a result of the default. Sometimes they'll pay, say, your taxes if they were you were paying the bank in escrow. Sometimes they will pay for homeowners insurance. They will take all of that and add it back into the principal amount. Again, that is something that they're allowed to do because a borrower did technically, and as awful as that sounds, did break their obligation to the bank, and they're still responsible for those missed payments. Sounds horrible, but that is how the courts will look at that. But ideally, they might kick the term back an additional 10 years, maybe, to make the payments a little more manageable. But that's something that you're going to see will change based on specific circumstances for people. So just giving you an overview, that's what a loan modification usually does. Post-conference, if you can't resolve the matter in the settlement conference part for whatever reason, the court is going to let the foreclosure proceed after a while. What that looks like is that the case will be assigned to a judge. The bank's going to need to submit 2 motions. The first is what's called a motion for an order of reference. And that asks for the court to appoint a third-party referee to calculate the total amount owed on the loan. Typically, from the time that you receive a motion for an order of reference or get removed from settlement conference to order of reference, it's about 3 months. After that, about 3 months from order of reference till you get to the next motion, which is for a judgment of foreclosure and sale. That's where the bank asks the court to let them sell the property at a foreclosure auction. So all total, from the time that you are released from the settlement conference part to the time that the bank is looking realistically at scheduling a sale date is about 6 months. That's the traditional time frame that takes. Could be short, a little slightly shorter, could be slightly longer. Generally, you're looking at about 6 months there. At that first motion for an order of reference, if you did put in an answer, that's when those issues will be decided. Because the judge will look at that. If you might want to put in, there might be some additional documents that the court will look at or that an attorney will put in, but the judge will decide the answer or any questions of law or questions of fact that you might have raised in the answer at that time for that motion for an order of reference. If your house goes to auction and it is sold post-auction, the buyer, whoever that might be, may start an eviction proceeding against you. We will be discussing that in a little more detail in an upcoming presentation on our Facebook Live and YouTube accounts. So please stay tuned for that. It's going to be a joint presentation between myself as the Foreclosure Prevention Unit and one of our housing attorneys. Don't have a definitive date for that, but stay tuned. COVID update here, very, very important. Because of COVID and people not wanting homeowners to be kicked out of their houses without a good chance to at least show up and try to work with the bank, courts are required to schedule an additional conference. This is outside of settlement conference part, so it's going to be a little different, but it's an additional status update before they can rule or schedule a date to rule on the order of reference motion and the judgment of foreclosure motion. If a borrower does not appear at the first conference, they will schedule a second one. If the borrower does not appear at the second one, then the court's going to just schedule and rule on the motion. So you should be notified of both of those. Very important that you keep an eye on your mail at that time. Again, this does not apply to vacant properties. If the bank can show that the house has been vacated and is deteriorating, they might be able to go through this process a lot more quickly. So that tends to speed things up. During normal times, when you're looking at the COVID delays, it's going to speed it up even more relative to what the normal case timeline looks like. As a practical matter, even without these conferences, COVID restrictions will likely extend this time frame beyond that standard 6 months. But don't assume that that's going to happen. Assume that that time frame is going to be in place. That's going to take about 6 months from release of conference. Always best. Prepare for the worst, hope for the best. Prepare for the shorter time. If you've got some additional time, great. Additional COVID changes. Some things that we want to make people aware of here is that there has been a moratorium that's been in place. Basically, this is just the federal government, federal agencies really saying we're not allowing new foreclosures or existing foreclosures to continue for loans backed by a federal agency. And there's been a moratorium on foreclosures for FHA, VA loans, and USDA loans until at least December 31st, 2020. Fannie Mae and Freddie Mac loans. If your loan is backed by Fannie Mae or Freddie Mac, that moratorium has already been extended until at least January 31st, 2021. Now, I have not, and I've been checking regularly, received an official presser from the Department of Housing and Urban Development on extending that moratorium for FHA, VA, or USDA loans. It might happen. It might happen 5 minutes after I'm done with this presentation. But right now, prepare that that's going to expire for those loans at the end of the year. May change. It probably will change, but don't plan on it changing yet until we get some official notice from the Department of Housing and Urban Development on that. While the moratorium is in place, like I said, lenders can't start or continue with a foreclosure on these federally backed loans. Some servicers with loans that aren't covered, or some mortgage companies with these loans that aren't covered by this moratorium, are still following that schedule. It's really, at that point, if they're not mandated to, it just depends on what the company wants to do. Again, the FHA, VA, and USDA moratorium might be extended. I have not seen official press release on that yet. If you want to find out what type of loan you have or whether these moratoriums are in place that affect you, contact your loan servicer, the company that you normally send payments to and normally deal with on your mortgage. They will be able to tell you about that. If you need help, you might want to contact a foreclosure prevention attorney. Again, get some information at the end of the presentation on that. Next type of foreclosure. Remember, I said that there were mortgage foreclosures and then tax foreclosures. Tax foreclosures get their own special name. They're called in rem foreclosures. Because our office is located in downtown Buffalo, we do assist people with Erie County and City of Buffalo tax foreclosures or in rem foreclosures, both of which have been postponed at this time until 2021. City of Buffalo, if you owe taxes to the City of Buffalo and they are looking to start an in rem foreclosure proceeding and sell your property, the auction for that has been postponed to May 2021. Not sure which date yet, they haven't set one. The county, however, Erie County has not set a specific date or month. It will be in 2021 though. Previously it was going to be scheduled for December 10th, then it was postponed until sometime next year. They haven't set a date yet. Both the City of Buffalo and Erie County are still negotiating with with homeowners to get payment plans for these back owed taxes. You can do that now still. Foreclosure prevention project agencies are able to assist with that. If your house is owner occupied, absolutely reach out. You do need to, if you want a repayment plan, demonstrate a hardship that prevented you from paying the taxes to qualify for a payment plan with the city or the county. If you do want to claim COVID as your hardship, it may be tricky if you had defaulted or if you owe taxes from before COVID hit. So for example, if you owe taxes from mid-2019 onwards, the county or the city might say, okay, well, during 2020, absolutely, you suffered a COVID hardship, but that wouldn't have applied for the 2019 taxes. So they might need some additional explanation on that. So just something to keep in mind while you're looking at those things. But right now it is postponed, giving homeowners a little more time to do those negotiations. I would recommend, again, contacting an attorney to assist with that. Not sure how the negotiations, because a lot of time, traditionally those have been done in person over the course of a 3-day period prior to the auctions. I'm not sure how that's going to look in the post-COVID-19 area yet, but I expect that the city and county will let people know well before the auctions, how they're going to proceed with that. But always best to get a jump start on that and not have to deal with the in-person stuff, especially if we're still having some COVID restrictions regarding gatherings in May of next year. Another thing that we wanted to bring to people's attention is, unfortunately, COVID-19 is going to cause an increase in the amount of foreclosure actions, most likely. A lot of experts are saying that that's probably going to happen. We're already seeing an increase in foreclosure scams. And what a foreclosure scam is it's any unscrupulous agency or individual or group trying to take advantage of homeowners facing a foreclosure so they can get some money out of it. This, I know some people feel like the bank foreclosing on them is a scam for whatever reason. I'm not talking about that necessarily, but there are times, because it's public knowledge, that people will try to contact you for the purpose of scamming you out of some money. So scammers will target borrowers in foreclosure, and mostly they will target elderly borrowers a lot more. I've already seen an uptick for some elderly borrowers getting targeted by foreclosure scams. And that's been going on for a couple of months, where we've been seeing this trend upward. What they might do, this is a pretty common one that I've seen. They'll send a letter to a borrower saying that there's an auction scheduled next week or 2 weeks or a week and a half later. And they'll say, hey, but we can offer you this, incredible opportunity that if you want to, we can refinance you for a 2% interest rate, and we can knock off tens of thousands of dollars off of what you owe. If it sounds too good to be true, it probably is. So at that point, a couple of things that you can do. If you've been working with an attorney, contact them if you get one of those letters. If you are concerned, and say you've got you're in the settlement conference part, well, then it's probably not legitimate, because you can't sell a property when you're in settlement conference, as an example. But definitely something to be aware of. If it sounds too good to be true, it probably is. You should also contact your loan servicer, your mortgage company, and say, hey, is this legitimate? Is this something that I can qualify for? They have an interest in helping you prevent falling for scams, because ultimately they want you to be able to pay them. So they don't want some other scammer grabbing all of your money. Some other times a scammer will say that they could rework your mortgage after a sale. Really not possible. They might say they can ask for a payment guaranteeing a loan modification. Say, hey, we can definitely get you a loan modification. You just need to pay us $5,000. No reputable organization would ever say that they can guarantee a modification. They'll say that they can help you apply for one. They can review your financial situation to see if you might qualify for one. They can put in the application and try to work with the bank to get you one, but no reputable organization can guarantee that. Another common scam that's going around right now is a phishing scam. Phishing with a PH, not with an F. And that is where the scammer will call you pretending to be your lender and try to get a bunch of additional information, a bunch of personal information from you. Sometimes they might call and say, this is your lender. You've got a foreclosure scheduled for this day. We want to work with you. Please give us your social security number. Again, if it sounds off or you feel uncomfortable, best thing to do, hang up the phone. Call your lender directly, because if your lender has sent you mail or a mortgage statement, there will be a number on there that you can call. Call them directly. Say that you got this phone call, that you might qualify for this option. They will let you know if you do or not, and if that's legitimate. You should always call them directly if you have a concern about a call you've received, because then you're talking to the right person. Now, maybe the person who you talk to with your lender might not know some of the intricacies of what's already happened, but you know that you're talking to at least the right company, and you're giving them information that they already have. And you should be able to get your loan looked up with your loan number. If it sounds weird or if it sounds suspicious, always best to hang up, call your lender directly, and speak with someone that you know is one of their employees. That kind of brings us to the end of today's presentation. A couple of takeaways is that the foreclosure process in New York State is very long. COVID-19 has delayed things profoundly. There are so many delays that have happened right now. A lot of things are on hold. That is probably going to pick up sometime at the beginning of 2021. But keep your eyes and ears open. Keep an eye on your mail. Make sure that you got a record of what your lender has been trying to talk to you about. And make sure that if you need it, if you think you need some help, contact a reputable attorney. Center for Elder Law and Justice, our services are free and available to borrowers. Only criteria that you have to meet for our services is the same criteria you need to meet for settlement conference. Reside in the property and you want to retain it. You want to keep your house. Please reach out if you have any questions or need some assistance. Our address, 438 Main Street, Suite 1200, Buffalo. We ask that because of COVID, if you want to schedule an appointment, you call in advance. We are not accepting walk-ins at this time, just to make sure that we can take the appropriate precautions to keep us safe, keep you safe. Making sure everything's sanitized, making sure everything is clean, and everyone's going to be masked up. Make sure that you're all set and that you are going to be safe. Also, Foreclosure Prevention Project. This is where if you want to leave your information, someone will call you back within a business day. Area code 716-828-8428. Because of how we are funded to keep these services free to homeowners, it does impact how we divide cases between these three agencies. So I do recommend if you are having a mortgage foreclosure or a tax foreclosure issue, call the Foreclosure Prevention Project intake line and we can connect you, or you'll be connected with someone pretty quickly. Can do an intake for you, see if we can assist you. Got a chat, which I believe no questions on Facebook, which is great. But if you do have some questions, if you're watching this in the future, a couple of things to remember, closing thoughts. If you're watching this in even later 2020 or 2021 and beyond, things have probably changed. Please call Center for Elder Law and Justice. We can answer those questions for you if anything has changed, or call your loan servicer. If you have a question, give us a call, drop it in the comment. Probably easiest to give us a call and could probably answer that for you really quickly. But always a pleasure presenting this information. I really hope that it helps a lot of homeowners or get an idea of what this process is looking like. If you're having issues, no shame in reaching out. One thing that you learn about this is that these problems, especially during COVID, can happen to anyone. Reach out, get connected, and a lot of the time, can't guarantee an outcome, but it's at least worth having someone helping you, sticking up for you, making sure that they can help negotiate with the bank on your behalf. But that is it for me for today. And thank you so much. And if you are watching in the future, I certainly hope that the vaccines have been distributed and that we're back to a semblance of normalcy. So thank you so much.